Hello, I'm Stephen Gold, author of The Return of Breaking Law, and in that book you'll find a wealth of material on the new divorce laws, along with the tactics to be employed when it comes to the finances in matrimonial proceedings, whichever side of the fence you're on. And this video is not just for going it alone as a litigant in person, but for lawyers, legal executives, paralegals, and even the office roofer if he lends his hand to a family department from time to time. And if you fear I might be talking out of the back of my head, well, you could be right, but you aren't. As a former judge, and I was lauding it up until last July, 50% of my time was spent dealing with family cases. I reckon to have granted literally thousands of divorces and other matrimonial decrees in my time, and refused a few.
Okay, Gold. You've got the job. Just get on with it.
Fair enough. Divorce laws are changing on the 6th of April next, 2022, but not the laws on finances, the financial remedies stuff as it's called. And the changes will not affect any cases that have already been started or are started before the 6th of April. They will continue under the current law. If you want to use the current law before the 6th of April, I'll talk about that a bit later.
Are the new laws a big deal?
Well, as big as they get, they represent a major reform. At the moment, the only way of securing a divorce is to prove that one or more of 5 factors have arisen. The other party has committed adultery and you find it intolerable to live with them. The other party has behaved in such a way that you cannot reasonably be expected to live with them. That's a watered-down version of what used to be the divorce ground of cruelty. The other party has deserted you, walked out on you, and that was at least 2 years ago. And then 2 other grounds, not involving any allegation of blame, but based on you having lived separate and apart for a given period. 2 years if there is agreement on a divorce, 5 years if there is no agreement. As from the 6th of April, those factors are scrapped. No allegation of any blame against the other party, and no allegation that you've been separated. Simply a statement when you start off the divorce case that the marriage has irretrievably broken down. You may be the cause of a breakdown. You and your partner may still be living under the same roof. You or your partner may never have attempted to mend the marriage through marriage guidance or mediation. It won't matter. Once the case has been started by an application, which will include this statement that there has been an irretrievable breakdown, and once 20 weeks have been clocked up from when you started the case, you'll be entitled to ask for that divorce. And that ask, like starting the case, will not involve any court hearing at which you'll need to be present generally. And once the court decides that you can have your divorce, a provisional divorce will be ordered, equivalent to the present decree nisi, which you can apply to be finalised at any time after 6 weeks and 1 day have elapsed from the date of a provisional divorce. That final order, when you'll be liberated from the marriage and the champagne may flow, will be equivalent to the present decree absolute.
So how does that pan out time-wise, from beginning to end?
Well, in an undisputed case, and 999 out of 1,000 will be undisputed, things won't be radically different to how they are now, but much will depend on how long it takes for the court to do its bit. So summarising, we've got the 20-week wait from starting the case to being able to ask for the provisional divorce, say around a few days for you to get in your request for the provisional order, then 6 weeks and 1 day before you can ask for the final divorce order, and a few days on top for the court to turn around that request. From beginning to end, I would estimate a very minimum of, say, 30 weeks.
How long must you have been married before you can divorce?
Well, there's no change in the law on that one. 1 year and not a single day short. The court does not have the power to cut down on that 1 year.
Which of the parties brings the divorce proceedings then?
Well, you can generally have just one divorce for one marriage. Once one party has started a divorce case, then provided they get on with it, the other party has lost the race. If, having started the case, they went to sleep and didn't take the next step, then the other party could get the court's permission to bring their own divorce case. It will be possible, though, for a joint divorce case to be started by both parties. You both apply, and then neither can brag to their cousins and their cronies, "Oh, they gave me the divorce, not my other blasted half, obviously felt sorry for me." The joint case could, though, cause a bit of delay if one of you does drag your feet. But whether it's to be a sole quest for a divorce and who goes for it, or a joint one, that may be dictated by...
Who shouts the louder?
No, money. There's usually a court fee to be paid, £593 for a divorce. Well, it's going to be very, 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 very difficult to persuade the court to order the other party on a single application for divorce to reimburse you that fee or contribute towards it. Unlike under the current law, the court can be expected to take the view that whoever brings a case which is undisputed should bear the court fee for doing so and any other costs where a lawyer's been involved. Well, you may say to the other party, where you're still speaking to one another, that is, well, I'll do it provided you hand over the 593 or say half of it, and do that now, or provided you consent to an order being made in the case that you will reimburse me. Now, if you're on certain benefits or low income with little or nothing in savings, you may qualify for no court fee or a reduced court fee. That's under the Help with Fees scheme. See my book on this, Chapter 17.
Plugging again.
Well, I was just trying to assist. To get help with fees on a joint application for divorce, you must both qualify financially. But say you qualify, but your spouse has scooped the national lottery twice, then it would make sense to have a single application by you and not a joint application for divorce. So otherwise, you'd be knocked out of the Help with Fees scheme.
You said earlier that 999 out of 1,000 cases would be undisputed. Why is that?
Well, it's because that in the main, the only allegation of fact being made in divorce is that the marriage has irretrievably broken down. No more rebuttals by the other side about not having spent the night in the hotel room with that woman, or I didn't pick my nose over breakfast, or we've only lived apart for 4 years, 364 days and 90 seconds, and not 5 years. Now, you might have thought that it would be legitimate in a divorce case by one party for the other party who is opposed to divorce to say, but that's nonsense. We've had our troubles, but the marriage hasn't broken down irretrievably. There's still hope. Let's go to relate. And anyway, we're still sleeping together. And only last night, you allowed me to buy you the dinner tasting menu at the Ritz, and we drank the finest wines. Well, on the face of it, the court can't go behind the statement that the marriage has irretrievably broken down. When it comes to decide whether you've done everything procedurally correct and you should have that provisional divorce. This means that the other party cannot put in an answer, in effect a defence, simply on the ground that they dispute irretrievable breakdown of marriage. However, they can dispute the case on very limited grounds. They are that the marriage never actually took place, or that there was no valid marriage ceremony, or that the ceremony was abroad and it shouldn't be recognised by our courts, or that the court does not have jurisdiction to deal with a divorce because neither you nor your spouse are domiciled or resident in England and Wales, or that you weren't served with the court papers when you should have been, or that your spouse has acted fraudulently. Whew. Is there absolutely no way that a challenge can be made to a statement that the marriage has irretrievably broken down when it is plain as a pikestaff that it hasn't? Well, I suggest there may be, and that would be an application for the case to be struck out as an abuse of the process of the court. But professional legal advice on the particular circumstances of your case would be wise before embarking on the course of such an application.
That's divorce then. What happens with the other ways the court has to end a relationship?
Well, ending civil partnerships will work the same way under the new law. There are mirror rules, same forms, same fee, same procedure, But the position changes when it comes to separation. It will be called judicial separation in a marriage and just plain separation in civil partnership. Sorry, civil partners, only a tiddly piece of discrimination there. What are the differences between the ending of a marriage or civil partnership and just an order of the court confirming that you're separated, which you would have known already? Well, the separation order can be used as a means of procuring a financial order which couldn't otherwise have been made, though you can't get a pension sharing order with just a separation, and the court cannot dismiss financial claims forever. And the separation case can be started during the first year of the marriage or civil partnership. And it might suit someone who wants to put the relationship on hold, believing it isn't yet totally dead, or who's resistant to liberating the other party so that they can marry or partner someone else. The court fee for separation is less than for divorce or civil partnership dissolution, £365. And if you wanted a divorce or partnership dissolution at some time after you'd procured a separation order, then you could apply to the court for one.
Say my spouse or partner applies for a separation, but I want a divorce.
You ask all the right questions. This situation is catered for. You can apply for that divorce in the same proceedings. The court would then fix what's called a case management hearing and give directions about what should happen. And unless I am a banana...
Is that the same banana as last time?
Yeah, the same banana. Unless I am the banana, the court would say that the case should go ahead on your application for a divorce and that the separation application should be halted. You might also find that one party wants a divorce, but the other party wants a nullity order.
Now you're making my brain hurt. Nullity, you say?
Nullity, I do indeed say. First, let me make it clear that the law on nullity is not changing. If the marriage or partnership are ended with a nullity order, then you're treated as having never been married or in a partnership. Effectively, it didn't happen. Now, you need a specific ground for nullity. For opposite sex relationships, a willful refusal to consummate or an incapacity of either side to consummate are among the grounds. For same sex or opposite sex relationships, among the grounds are that the other party was suffering from venereal disease in a communicable form or was pregnant by somebody else at the time of the ceremony.
You've explained that with a divorce or ending of a civil partnership, there are two orders, the provisional order and then the final order. Is there any way that the final order might be delayed so that, say, a remarriage or civil partnership ceremony has to be postponed?
Well, a straight answer to a straight question. Yes. The final order isn't made automatically. You have to complete a form for it. You could delay doing so. If you delayed for more than 12 months, you would have to explain to the court the delay, the reasons for it. If you delayed for more than 3 months, the other party could ask the court to make the final order in their favour. There may be a good reason for the delay. For example, an application is pending for the finances to be sorted out, which you would want dealt with before final order, because your pension rights could be lost or prejudiced by the other party dying before the final order was made. But there is another route for delay. Under current law, the other party to a divorce or civil partnership dissolution case, which is proceeding on the basis of 2 years separation or 5 years separation, can hold up the final order, we call it a decree at the moment, by applying to the court to consider what will be their financial position after divorce or dissolution. And when they do so, the final order will be postponed until the court has decided that financial provision for them shouldn't be required, or that the financial provision proposed is reasonable and fair, or the best that can be made in the circumstances. The party after the divorce or the civil partnership dissolution can give an undertaking to the court to make financial provision for the other party. Concrete and specific proposals must be put forward, and if the court reckons they are not too wide of the mark and it's desirable for delay to be avoided, then it can allow the final order to be made. Well, in short, An application for this consideration to be given will cause some delay, inevitably, and is often used as a bargaining tool where early freedom from the relationship is yearned for by the other party. Under the new law, this application and so this bargaining tool can be employed by the other party in every single divorce and dissolution case. There are special rules for this to be done where the divorce or dissolution proceedings are going ahead on a joint basis.
The new laws applied from the 6th of April. Would you advise anyone intending to bring divorce or civil partnership proceedings to wait until then?
Well, as judges and lawyers are so fond of saying, it depends. If you want a cost order against the other party and you're able to rely on their adultery, unreasonable behaviour or desertion, it makes sense from an economic standpoint to start your case before the 6th of April under the current law. You will then have a sporting chance of the court ordering the other party to pay your costs. Also, if you reckon the other party will do all in their power to drag out the proceedings by making one of those applications for the court to consider what their financial position will be, which they can't do under the current law, but they could do under the new law, then start before the 6th of April. But if you have no grounds to go for divorce and so on under the current law, or you prefer not to make use of them, then all other things being equal, hold on until the new law is in force. If you're wanting to make use of the current law, then you'd better pull your finger out though. At the moment, you can bring proceedings online, digitally, or by post. To do it online using the current law, you have up to 4 o'clock in the afternoon on the 31st of March. After that, the online system will be unavailable as it is modified to cope with the new law. But you can still bring proceedings by post or in urgent cases by email. However, there's no guarantee that even if the paperwork is received by the court before 4 o'clock on the 5th of April, proceedings will be formally issued by the court in time. If unissued by then, the threat is that the paperwork will be bounced back to you and you'll have to rely on the new law and start all over again.
Once the 6th of April arrives, how will cases be started and then managed?
Well, let's take divorce and civil partnership cases. New proceedings and new forms, but otherwise in a similar way to now. This is the new application form for online or offline. Only 20 pages, but it's very user-friendly. Even I can understand it. If you're doing it yourself without a solicitor, you have a choice, online or by post. If you're a solicitor, generally you have to follow the online procedures, so check the Wi-Fi is okay. Where there's a joint application, it's contemplated by the court service that a single solicitor may act for both sides. Well, I fancy that most solicitors will shy away from doing that, as there could be a conflict of interest. But if any solicitor is persuaded to do so and make a joint application, this will have to be by post and cannot be digitally. So far as proceedings for separation or nullity proceedings are concerned, the online facility will not be available by post there. If a divorce, dissolution, separation or nullity case is going to be defended and an answer has to go in, as I've mentioned, this form, the answer, will be used, form D8B, and remember, an answer will be rare, and this cannot be done online. It has to be done by post, putting in the answer.
Supposing there are existing proceedings, say for divorce, which are being defended, what happens to them?
Well, the high probability is that the divorce under the new law could not be successfully opposed. And so in the situation mentioned, serious consideration should be given to abandoning the present defended proceedings and restarting under the new law after the 5th of April. How the costs of the existing proceedings are dealt with will be a matter for negotiation or decision of the court. But if no lawyers have been involved, that might not be too much of a worry.
There have been some name changes to come in with the new law.
Yeah, that's right. I will still be Stephen Gold. The idea of changing it to Stephen Silver or Stephen Platinum has been flatly rejected. More importantly, the divorce lingo has been allied with the civil partnership lingo. Instead of decree nisi, we have conditional order, what I've been calling the provisional order. This is the form you complete to get that. Instead of decree absolute, we will have final order. A judicial separation decree in a marriage becomes a judicial separation order. A decree of nullity of a marriage is turned into a nullity of marriage order. I hope you're not finding this too exciting. The document starting off a case will be called an application, whatever the type of case, instead of the present grand title of petition. And defended proceedings will be called disputed proceedings. Not an earth-shattering change, that one.
For any more information, where can our viewers go?
Well, there's an information pack issued by the Ministry of Justice, which can be accessible online. And as I think I just may have mentioned at the top, there's much on the new law, and in particular on tactical moves, to be found in my book, The Return of Breaking Law, which covers a wide variety of legal situations and remedies far beyond those of a matrimonial nature. Well, from now, from Law Watch, it's goodbye, and you could always try for a reconciliation.